morning, everyone, and thank you for being here. I am Paola Gaffurini. I represent the Open Dialogue Foundation. I will be the moderator at this side event on the application of the Magnitsky law. First of all, I would like to thank case members that are here with us, Roberto Rampi from Italy, André Gatolin from France, and Mr. Peter Omzicht from the Netherlands. Also, I would like to thank our partner organization, NGO, the Italian Federation for Human Rights, that today is here represented by its Vice President, Eleonora Mangelli. So, together with the Italian Federation for Human Rights and other NGOs, we have started to campaign for the promotion of the application of the Magnitsky law in different international platforms and also national parliaments, such as, for example, the Italian Senate, promoted by Senator Rampi. As you know, the Council of Europe has been one of the leading institutions in promoting the Magnitsky law, and during the last winter session, they adopted a very comprehensive report, a resolution on the matter, exhorting member states to integrate this mechanism into their national legislation. So today, together with our guest, we will try to tackle concrete questions related to the implementation of targeted sanctions towards state actors, non-state actors, so basically individuals that are responsible for human rights abuses and systemic action of corruption here in the Council of Europe. And together with experts, we'll explain how the personal sanctions enforcement mechanism effectively operates in countries where it was and it is already applied, what is the process of evaluation, of imposition and removal of targeted sanctions. And then we will present through direct testimonies of victims of human rights abuses and political persecution in non-democratic countries. We will present through their stories, which is the impact of such legislation, the impact on victims, and also the impact on human rights defenders that combat this feeling of impunity. So I would like to ask Senator Rampi to open this event with some introductory remarks, and then we will give the floor to our speakers. In order to save time, I won't introduce them, and then I will ask case members to make some concluding statements. Thank you very much.
Thank you very much, Paola, and thank you very much to everyone who works a lot for that event. I believe that we are in a turning point for human rights, and it's a new era also for democratic country and for non-democratic country that sometimes use the democracy only like a form of democracy, not a real democracy inside that. The Magnitsky Act is something new that is very interesting because can be really something that is really working about the people who does go against human rights and not to all the country, all the people of that country. That is a very, very important changement. We know we had problem about the real solution of human rights in some countries. Many times we try with resolution to fight against the country who don't support human rights, but that fight is only theoretical. We do a very great resolution, but nothing change in that country. So we believe that the Magnitsky Act is something that can change this status, and as you said, is something that we want to do very correctly. So very strong, with people who go against human rights, but also very correct to the position of not having in that list people that have not to be there. It's very important. So today we have two opportunities. The one of hearing directly from the voice of people who fight in their country to the respect of human rights, how it's important that we, all the country, adopt a solution like that, and from expert exactly how it works, and also the first results and the first new to pay attention about that. So I believe that is a work moment, that one. We have to learn a lot. For me it's very important also because 24 members of Italian Parliament give their signatures to my proposal. We really want to involve different party and different organization in Italy, because we don't want to just say that we want Magnitsky Act. We really want to improve that, to let that works in a country like Italy, that have a very, very different system of law, for example, from other countries that already use that. That's not so easy, so we wanted to be also a test for Magnitsky Act inside a different law system. I believe that our expert can also explain us something about that. So thank you very much for everything, and I'm here to learn that. And I also thank you some Italian colleagues that are here to understand better. Thank you.
Thank you, Senator Rampi. So I would like to give the floor right now to Jared Ganser. He is a U.S. human rights lawyer, and he has a broad expertise on the application of Magnitsky law in the U.S. context. So please, Jared.
My name is Jared Ganser. I'm a human rights lawyer based in Washington. I have spent my entire career working on behalf of victims of human rights all over the world. I'm best known for my work freeing political prisoners, having represented people like Aung San Suu Kyi and Liu Xiaobo during times that they were detained. I also teach at Georgetown University Law School and have published a number of books on human rights. So in my brief presentation this afternoon, I'm going to talk a little bit about, overall about best practices for developing and applying global Magnitsky sanctions. And that will include talking about the scope of typical sanctions, providing their current potential application. Next page. Explaining key elements to lodge an effective complaint with relevant authorities, and then examine forthcoming developments. Next page. And you can just hit it a number of times to fill in all that. That's fine. One more. Let me just talk through this in brief. I am happy to provide to anyone who wants it, if you want to give me your card, a copy of the presentation itself, so you don't have to feel like if you were interested to take notes. But overall, while there are different approaches to applying Magnitsky sanctions globally, in general, they are applied to individuals and entities that are involved in gross human rights abuses, which include such things as killings, torture, or other gross violations of internationally recognized rights, and then also against people involved in grand corruption. I'm going to focus today, because of the panel that we have together, on Magnitsky sanctions as it applies to gross human rights abusers. So in light of limited resources around the world, and this, of course, the numbers of abuses going on, these kinds of sanctions are most frequently applied against what are often called the worst of the worst, right? So we're not talking about people who are imposing a set of violations or an individual torturing someone once. We're obviously, as bad as that is, and as much of a violation of domestic and international law as that is, but we're talking about people who do this on a more systematic basis. So we're talking about people like the head of a security agency that tortures dissidents, or an agency that runs a country's prison system that imprisons political prisoners, or judges and prosecutors responsible for imprisoning not just one or two prisoners, but many, many prisoners. The head of a government-sponsored death squad. These are all kinds of examples. And in terms of the kinds of sanctions that we're talking about applying against these individuals, we're talking about asset freezes, which means freezing bank accounts or making it impossible for them to sell assets, including property. We're talking about blocking people. The term blocking people means that they are prohibited from doing business with, in any way whatsoever, directly or indirectly, with a person who's a national of a particular country. So if you're on the sanctions list in the United States and you're a blocked person, I, as an American citizen, am prohibited from doing business with any such person, and I could even go to jail if I do business with that. And then lastly, of course, we're talking about travel bans and or the revocation of existing visas. Currently, we have a range of countries that have adopted domestic legislation on applying these kinds of sanctions. The US, Canada, the UK, Estonia, Latvia, Lithuania, and the Netherlands. The EU is considering doing this more broadly. Australia, obviously now Italy, and a number of other jurisdictions are looking at doing it. But we're really early days in terms of having global efforts, country by country, to create this tool and then to apply it. Next page. And then
I, as an American citizen,
so to bring to life who we're talking about, on the left side you'll see a number of people that have in fact been targeted for global Magnitsky sanctions in different places. So we have, for example, a Chinese security official who's been involved in the deaths of a number of human rights activists, including the famous case of a Chinese human rights defender who was literally about to get on an airplane to Geneva to testify before the Human Rights Council, and she was stopped from boarding the plane and then imprisoned and died in Chinese custody. You can see as well those people linked to the Rohingya genocide, a minister in South Sudan who's been fomenting ethnic violence, etc. We're also talking about, for example, Venezuela. Canada has listed under its list the head of the National Electoral Council of Venezuela, who facilitated the fraudulent elections that resulted in Maduro's election to be president. And then on the right side, you see 3 examples of potential people to be sanctioned that have a connection to individual cases that I'm personally working on. Somebody like the Mr. Kasimov, the former Minister of Internal Affairs of Kazakhstan, who you'll hear from his son Ali shortly, who's here with us today. And Kasimov has been involved in a range of cases of political prisoners, as well as extrajudicial killings, torture, and a range of other offenses. Next page. And then you just, keep going. Thank you. So what is the process for evaluating, imposing, and removing global Magnitsky sanctions? So the laws are implemented in different ways, depending on the country you're talking about. In the US, for example, it's the Departments of State and Treasury that work together on these potential listings. In Canada, there's a new sanctions office in their foreign ministry, which consults with its Treasury Department and then proposes listings for approval by the cabinet. There's not a right or wrong way to do it. Obviously, a law will define how that's going to happen. How do you identify targets? Well, potential targets can either be identified by governmental or intergovernmental institutions deciding privately with themselves that they believe a person or entity should be potentially investigated, or by the submission by a credible, by one credible or multiple credible sources, NGOs or other outside parties. And I'll talk in a moment about what kinds of information is most useful to governments when listings are considered. In terms of the standard for review, again, these are all defined in domestic law. One potential way that it's been done is to look at what's called credible evidence. So has credible evidence been presented that the person or entities are involved in gross human rights abuses or grand corruption, or a more likely than not standard, which is a little bit more than half. Anything over half, more likely than not that a person's been involved in these kinds of activities. What kinds of information are reviewed? The U.S. is an exception, I'll mention in a moment, but generally when countries have implemented these kinds of laws, what you see is that they're looking for credible and publicly available information. So you're looking for reputable NGO reports, you're looking for reputable media reports. This is the kind of evidence that governments typically look to. In the U.S. context, information is also checked with intelligence sources. So information that might have been gathered from public sources is it's sought to be verified through intelligence sources and methods. And then lastly, appeals processes. It's worth noting, in my view, that it's, as a human rights lawyer, that it's important that there be a presumption of innocence, not just on criminal cases, but on these kinds of listings, and that the evidence threshold should be proactively achieved rather than presumptively assumed. And so, again, appeals processes are different by country, but there needs to be a strong mechanism for appeals to be able to happen. It is, could be very damaging to these kinds of global efforts to advance Magnitsky sanctions if mistakes are made, if people are wrongly put on these lists. And so it's very, very important that, that great care be taken not only in the individual laws that are being put forward country by country, but that the way that evidence is gathered, the standard of evidence that is being put forward, et cetera, guarantees as much as humanly possible that these listings are accurate. Next page. So I've only got 2 more pages here and then I'll be finished. So a lot of people ask me quite regularly, you know, what should an NGO be looking at when making a submission to a governmental or intergovernmental institution? And again, remember, we're talking about identifying people who are the worst of the worst, involved in many, many cases. And so you're looking at what is the biography of the person involved, and any actual identifying information that you can find. It's very hard to do that, but you know, to know their date of birth, to know any identity document information. This is the only way that, of course, banks or global institutions can potentially enforce sanctions. Obviously, you know, with people's full names, then you can do a certain level of work, but often people have names that match many other people's names, so you need identifying information. You want to talk about that person's role. So for example, a person who runs a prison, you know, how is it organized, how many people are there, how has that prison been used to abuse political prisoners, with as much independent reporting as possible, as much quantified in numbers as possible as well. Then, in addition to that information about the person and their institution, we want to look at eyewitness testimonies. So for example, a compelling, kind of particularly compelling case would have at least 10 to 20 examples. If we're looking at, for example, someone who runs a prison that imprisons political prisoners, you know, 10 to 20 testimonials from current or former prisoners to explain their experience. Some of this may have to be anonymous if people are afraid to provide information, but people can be named as much as possible, and you'll see there are a number of things that should be included. And the idea is that when you make the submission, you know, these testimonials don't have to be very long, but you know, a couple of pages each, even 3 pages, if they're well put together. And you know, you would attach the testimonials on top of a submission on behalf of against an individual person and their institution to bring to life why this person is among the worst of the worst. It's not just about 1 or 2 cases. That is not sufficient to be considered for a listing under Magnitsky, global Magnitsky legislation. You know, you really have to show that there are many, many cases that that person is responsible for. And then lastly, making your own arguments, not only about why that person is the worst of the worst, but also how the listing will help victims, change behavior, and send a clear message that global impunity will not be tolerated. Last page, please. So, you know, when we're looking at within the EU, a number of members have already adopted their own local laws, including Estonia, Latvia, Lithuania, the Netherlands, and the UK. You know, the reality is, though, that it is still, as I said, very, very early days. Very few individual sanctions have actually been imposed under these laws. And even in the U.S. context, our first set of listings happened, you know, last December. I'm sorry, December of 2017. And we still only have, you know, in the United States right now, about 25, 30 people individually listed and about 30 entities listed under global Magnitsky. So we're still very, very early on. You know, as you, I'm sure, are aware, the Dutch government is working through the EU to create a EU-wide global Magnitsky law. I think that to conclude, you know, I do think it's very important to talk about the importance of coordination and the sharing of best practices across the world among jurisdictions, countries with jurisdictions that are putting in place these kinds of laws. We've started to see it, for example, on Russia-occupied Ukraine, where the EU listings and the US listings came out at the same time. But when you talk about, for example, starting to sanction people for gross human rights abuses, it will be much more effective if a number of jurisdictions around the world, all at the same time, talking to each other privately in advance, decide, okay, we're now going to do something, for example, on Russian political prisoners and those involved in their persecution. Let's have a common agreement on the best perpetrators that we can identify, and then on one day, having all these jurisdictions to sanction someone. That would send a much more clear message. And then lastly, I'll just note, as you know well, PACE has adopted a resolution recommending that national governments within the Council of Europe implement their own domestic global Magnitsky laws. but obviously substantial follow-up is necessary so that that can happen at the national level. Thank you very much.
Thank you very much, Jared, for these very concrete examples and recommendations. So before listening to the story of Eleonora Bekirova, I would like to show you a short video about the story of her father.
Це Едем Бекіров, йому 58. 18 з них він бореться за життя. Інвалід першої групи із цукровим діабетом і з раною, що не гоїться на місці ампутованої ноги. Просто, щоб жити, чоловікові щодня необхідні 1,5 десятки медикаментів і перев'язки тричі на добу. Трохи більше року тому на долю Едема Бекірова випало ще одне складне випробування. Він переніс надскладну операцію на серці. Йому встановили 4 шунти на серці. Едем Бекіров тоді був на межі життя та смерті, і лікарі не давали жодних гарантій того, що після операції він прийде до тями. Стаття, за якою Росія... Та найскладніші випробування лише починалися. У грудні 2018-го Едем Бекіров мав пройти плановий курс лікування у стаціонарі. А перед цим хотів навідати стареньку маму, що мешкає в окупованому Криму. 12 грудня о 7:45 ранку він на таксі приїхав до КПВВ Чонгар, і зв'язок з ним обірвався. Лише ввечері Едем Бекіров зателефонував додому і приголомшив усіх. Він в полоні у російських окупантів Криму. Виявляється, його схопили на адмінмежі з тимчасово окупованим півостровом російські прикордонники. Після виснажливих кількох годин допиту тяжкохворого Едема Бекірова доправили до управління ФСБ без життєнеобхідних ліків і навіть води.
Через адвоката связался он с мамой. Он сказал только 2 слова, попросил лекарства.
А вже наступного дня Едем Бекіров опинився на лаві підсудних в окупаційному суді Сімферополя. Після доби у відділку ФСБ без їжі і ліків Едем Бекіров ледве тримався на ногах. У скляній клітці судової зали чоловік ледь не втрачає свідомість. У нього падає цукор крові і піднімається тиск. До суду терміново викликають швидку. Стаття, за якою російські окупанти зібралися судити тяжкохворого кримського татарина, вражає своїм цинізмом. За версією окупантів, Едем Бекіров, щойно опритомнівши після операції, повіз до Криму, уявіть, 14 кілограмів вибухівки і 200 набоїв. Адвокати на цьому показовому судилищі намагалися пояснити очевидне. Їхній підзахисний після надтяжкої операції на серці не міг піднімати нічого важчого за пляшку води, не кажучи вже про 14 кілограмів вибухівки. Але окупаційні судді адвокатів не почули. Інваліда першої групи з протезом на місці ампутованої ноги без жодних на те підстав запроторили до Сімферопольського СІЗО. У нелюдських умовах спецблоку Едем Бекіров проведе наступні 2 місяці. Просто за те, що він кримський татарин і не визнає влади окупантів в Криму.
Добрый день, уважаемые господа. Я сюда добралась по вашему приглашению только с одной целью, чтобы вы это услышали. Я не хочу, чтобы вы это прочувствовали. Я хочу, чтобы вы это услышали.
Ladies and gentlemen, I'm here on our invitation. And I do not want you to feel all this pain. I just want you to hear the story.
В Крыму берет свое начало то, что поглотит потом и Европу при бездействии, если это не прекратить. Путин и его армия ФСБ тренирует на нас, на крымских татар, на украинцах свою репрессивную машину.
The things that are happening now in Crimea then will absorb Europe if they are not stopped. Putin and his army and his FSB army are training their repressive regime and their repressive machine on us, on Crimean Tatarian in Ukraine.
27 марта 2019 года произошли те события, о которых я вам сейчас расскажу.
On 27 March 2018, the events about what I am gonna tell you happened.
27 марта в домах 35 крымских татар вторглись в ФСБ. Это были не обыски, это были облавы сразу на нескольких крымско-татарских районах с оцеплением и прочесыванием, в ходе которых одновременно в разных местах Крыма массово обыскивали дома и задерживали людей.
On 27 March, Crimean Tatars were 23 Crimean Tatars were detained. As it became known later, they were blindfolded, so put in a plane and taken from Crimea to the Rostov region. Before that, some of them were taken through the forest and beaten to a pulp. They were illegally detained, and they've been held in 5 detention centers in Rostov regions. The 24 person involved in this case, Crimean Tatarian Edim Yachinkov, is missing.
27 марта были задержаны 23 крымских татарина. Как стало позже известно, что их вывезли в масках и увезли в Ростовскую область. А до этого некоторых из них вывезли в лес и избили до полусмерти. 24-й фигурант этого дела, Эдем Яйчиков, до сих пор без вести пропавший. На тот момент в доме его не было, его машину обнаружили в Симферополе, но адвокаты утверждают, что он находится в ФСБ. ФСБ эту информацию отмалчивает.
According to the lawyers of the missing persons, he is detained in FSB facility, but of course Russian government is denying this information.
За 4 минуты невозможно вам рассказать все события, которые происходят в Крыму. Я думаю, что в докладах и отчетах, которые вы получаете, есть достаточная информация.
I don't have time in these 4 minutes to explain everything that's happening now in Crimea, but I am perfectly sure that you are having all this information, receiving through the all reports and monitoring commissions, committees which are working on Crimea subject, which is very important for me and my family.
Если будут ваши имейлы, я смогу вам отправить, подробно расписать и отправить вам.
Also from my side, I'm ready to send all the information about the situation of my father.
Это дело не 4 минут.
Unfortunately, it's not about 4 minutes.
В Крыму идет преследование по национальному и религиозному признаку.
In Crimea, the minorities are under the risk to be persecuted because of their religion and because of their nationality.
Мой отец Эдем Бекирован призван террористом по сфабрикованному делу. Его посадили в тюрьму и по сфабрикованному делу хотят сгноить в тюрьме.
My father Edem Bekirov is now in prison, is for more than 100 days in prison because of a fabricated fake accusation, and he is not a politician. He's a normal man who is suffering just because he belongs to the Tatarian nationality minority.
Чтобы он оттуда никогда не вышел на страх всем крымским татарам.
I'm afraid that he will not exit from this prison, and this will be a big threat for the all Crimean Tatarians.
На сегодняшний момент в российских тюрьмах задержано 106 крымских татар, 24 военнопленных, 166 детей остались без своих отцов.
Today in Russian prisons are held more than 100 Crimean Tatars and 24 war prisoners, and more than 100 children they remained without their parents.
Вот так работает эта машина.
This is how it works, this repressive machine.
Я призываю вас принять закон Магнитского, входящие в персональные санкции в отношении тех лиц, кто причастен к задержанию и к репрессиям крымских татар и украинцев.
I'm begging you to help promoting this Magnitsky law and to impose sanctions towards those perpetrators who are grossly violating and constantly violating human rights and Tatarian who are living in Crimea.
Эти люди не должны остаться безнаказанными.
And these perpetrators should not be left in impunity.
Если не предпринять определенных шагов со стороны Европы, то эта репрессивная машина может завтра оказаться у вашего дома.
Because if we want to take a side, a strong side, tomorrow this repressive machine will come to us, to Europe.
Я Элеонора Бекирова.
Eleonora, sorry, I ask you to kindly conclude your speech.
Да, я шучу, попрощаться. Я Элеонора Бекирова, дочь Эдема Бекирова, томящегося в российской тюрьме.
Thank you very much. My name is Eleonora Bekirova. I'm a daughter of Emin Bekirov, who is now suffering in a Russian prison.
Thank you very much, Eleonora, for your testimony, and definitely the case of your father has been internationally recognized also by Ms. Mogherini and by several international NGOs. We are promoting the main message of Eleonora in a written declaration to ask to impose sanctions on these perpetrators. Now I would like to give the floor to Aliaskar Yeribetov. Please be brief because we are running out of time, so you have 2 minutes. Thank you.
Good afternoon, everyone. I'd like to, before I go on about the case of my father, I would like to just very briefly explain who my aunt is. She's a lawyer and she's a human rights defender that is based in Belgium. She's been given a political asylum in there, and she had to leave Kazakhstan about 6 or 7 years ago. My father, Iskander Yerimbetov, was arrested in November 2017, and he was kept in prison, and the officials told him that he needs to convince his sister to come back to Kazakhstan so that they could beat out the false testimonies out of her against the people that she has defended in the past. Obviously, as any honest man would do, he refused to do that, and for that he got tortured for over 2 months. Not only physically but psychologically as well. He was kept in a solitary confinement in a freezing cell without sufficient clothing for 2 days. Then he was also sitting in the same cell with convicted prisoners. He would repeatedly beat them up day after day, and sometimes even using objects like metal rods. But because obviously metal rods are too heavy for them, they would ask the police to bring like wooden sticks, and they'd happily do that for them. So they would wrap around the wet towels around the wooden sticks and just beat my father until he couldn't breathe. So yeah, that's not very helpful at all. And then after all, thanks to all the human rights organizations and some European political figures that have helped to stop the tortures, the trial itself was recognized as politically motivated, and my father was given 7 years in prison on fabricated charges. My father is a mathematician. He's a self-made businessman. He doesn't have anything to do with politics or any of the banking systems. So I think, coming on to UN Working Group on Arbitrary Detention concluded that my father is being detained in violation of the international law and urged his immediate and unconditional release, but Kazakhstan decided to not comply with it. So I would like to ask you all to help in any possible way that you can. We must stop torture, arbitrary detention, and human rights violations. Thank you very much.
Thank you, Aliaskar. I would also like to add, as our organization has followed closely the case of his father, that the case of Yerimbetov has been raised by the UN Working Group on Arbitrary Detention, and there are currently 19 out of 26 of UN recommendations on individual cases of arbitrary detentions, of torture and treatment in detention facilities that Kazakhstan has still not implemented. Among them, the most urgent thing are the one of Mukhtar Zhakishev and Max Bokayev, but there are also a number of other political prisoners that are kept in Kazakhstan under extreme charges. There is, unfortunately, in the country systemic persecution of peaceful protesters, which had led to roughly 700 arbitrary detentions since the banning of an extremism, the so-called opposition movement that has been labeled as an extremist movement, the democratic choice of Kazakhstan. So we are reiterating our messages once again in a written declaration, so if it's open to everyone, so if you can please support it, we will be happy. So I would like to give the floor to Emin Usinov for a very short statement, and then straight away to Anar Saki. Thank you.
Thank you very much. I don't want to focus on the issues with specific cases, even like my brother, which is supposed to be here today, is not able to leave the country because the illegally General Prosecutor Office stopped him at the border and said you are not allowed to leave the country after 2 years of imprisonment. And I know for in many countries like this, our relatives paid the huge price for our activities. We also lost our mother and colleagues from our organization. But now I would love to share which kind of sanction it's possible to implement. First of all, on the country level, like when EU member states and Council of Europe member state national parliament should adopt these sanctions. This is very important. And also sanctions or some kind of joint efforts or activities which is possible doing here in this house and Parliamentary Assembly of Council of Europe. Because even small sanctions or debate about these authoritarian countries, even members of the Council of Europe, is quite painful for authoritarian leaders, which especially have a membership in this institution. And also, of course, we need to think about the level of the sanction of the European Parliament. Now we know we have great initiatives and already global law in the US, but which is still, for me, not very practically working. Because in Azerbaijan, no one's still not in this law. But of course, it's also individual sanctions, what is very important, but it's also business institutions. Because dictators operated nowhere by persons which is tortured victims in the prison. The people which is tortured, the Magnitsky, not only them should be responsible, or people which is tortured corruption exposers in our country. Banks which is give these corridors or organize these money laundering mechanisms, they are stealing without any responsibilities, and impunity level is quite huge. And we call again to Parliamentary Assembly of Council of Europe we need to regularly follow up the issues with the money laundering, with caviar diplomacy scandal, with Azerbaijani Landromat scandal, Russian Landromat scandal, and especially we would love to invite you, all of you, to our upcoming side event, which is Nadir Bukarella supported with Mr. Omzik for next Thursday. The issues of our side event, which is we try to organize, it's a future of Council of Europe with zero corruption and more human rights and democracy, and we try to follow up the procedure for how to MPs should vote and elect best Secretary General. We know for now it's not 4 candidates, only 2. Croatian Minister of Foreign Affairs and Belgian Minister of Foreign Affairs, how civil society should operate, and how parliamentarians, because what we see now, a bit more accountabilities from PACE members after this scandal, but still we didn't see same accountabilities of executive bodies of Council of Europe. That is, we think we should all equal and accountable civil society, lawmakers, parliamentary assembly, and executive body institutions, started from Secretary General until head of the office. Thank you.
I wouldn't be able, of course, but I want to focus to the main word that I have heard from Jared's explanation, the worst of the worst. Sanctions should be imposed towards the worst of the worst. And I suddenly realized that the worst of the worst has happened in my country, which ironically, after signing an association agreement in 2014, experienced a rapid decline in justice, in rule of law, and everything that means human rights and respect for the freedoms. So now we can speak about perpetrators in the Republic of Moldova, and we can consider cases of people who are guilty in front of us of people. Okay, I'm referring now to the morality, but I'm able, and the team of the lawyers and civil activists in Moldova, which we are working with, are able to provide also juridical arguments. About the Plahotniuk, the oligarch who is staying behind the government in the Republic of Moldova, who is the main perpetrator in our country, who is the one who organized different severe crimes which occurred in last times in the Republic of Moldova, and who was and he is directly responsible for the political prosecution of the judges. And here we are talking about the case of Dominica Manoli, Gheorghe Balan, Dorin Munteanu, judges who've been recognized as victims of political prosecution in such valuable documents as Amnesty International reports, US State Department's reports, UN rapporteurs for human rights, PACE different reports and conclusions of monitoring committees which were working in the Republic of Moldova. I should mention, of course, lawyers and those who were defending whistleblowers and key witnesses, people who were talking frankly about the crimes, the severe crimes which were committed by Plahotniuk and his gang, and I'm telling about the gang and not about the government. Those lawyers, and unfortunately it's not only about me, the one whom I'm living abroad for 2 years because I cannot return to my country being politically prosecuted, being wanted by my government through Interpol. Of course, Interpol refused to do this, but 6 lawyers in the Republic of Moldova are in danger now only because they refused to give up my case, and only because they replaced me in the cases of when they have been defended people, families of people who were murdered. Either those people were simple detainees, as in case of Andrei Brăguța, or MPs, as in case of Ion Butmalai, who was killed in 2014 just because he expressed frankly and openly his position in Parliament of Moldova against Plahotniuk. I saw in the presentation of Jared, which is a very good turning point for me as a lawyer, that we should have a selection of people who might stay behind massive crimes. Such kind of people could be, for example, chiefs of intelligences. And I have 2 examples, and I will conclude with these 2 examples. The chief of Moldovan Secret Services, who was acting during the communist time, and who is directly responsible for the ordering to torture and to beat to death people who were protesting in the street, now was promoted by the oligarch as the president of the Constitutional Court of Republic of Moldova. And the second, who replaced him in the position of the chief of intelligence of Republic of Moldova, is the one who is responsible for prosecution of international lawyers who are working with the Republic of Moldova. And here is the case of Ludmila Kozlovska, the president of Open Dialogue Foundation, who is one of co-organizers of this great event. Ludmila Kozlovska was a victim of political prosecution in the Republic of Moldova only because 2 years ago she met a lawyer who was in danger, and she took my case, and after my case, she and her organization have taken dozens of cases of big political prosecution against those who are in opposition to Plahotniuk, and who developed the second very important chapter towards the future sanction according to the Magnitsky law. Big cases of corruption and big cases of money laundering that unfortunately also occurs in our country. So for Moldova, which is a member of everything, association agreements, Council of Europe, it's very simple to be brought to the responsibility, because everything that brings us in common here is the feeling of impunity. We came from countries where our perpetrators are not only free, they are in the governments. And we somehow failed to fight with them on our national level. So we must go into international level. And here Magnitsky law is real the way we should go. And we thank you very much for this attention, and we hope everybody who is attending this event will be near us on the day when we will be able to provide the juridical argumentation of the sanctions toward perpetrators in Kazakhstan, in Russia, in Ukraine, in Azerbaijan, and the Republic of Moldova, and in many other countries. Thank you very much.
Thank you very much, Anna. Now, before giving the floor to PACE members, I would like to show you a very short video from Bill Broder. He's the founder, CEO of Hermitage Capital Management, and he's the leader, initiator of the Global Justice campaign for the adoption of the Global Magnitsky Act. Thank you.
Good morning, this is Bill Browder. I'm head of the Magnitsky Global Justice Campaign, and I've been one of the principal advocates for passing Magnitsky Acts around the world. As you all know, we now have 6 countries with Magnitsky Acts: the United States, Canada, the UK, Estonia, Latvia, and Lithuania. And the big prize, of course, is Europe, the European Union. It's the big prize because without it, a major attractive destination for both dirty money and evil people is the European Union. People, these torturers and killers from Russia and Saudi Arabia and various other places love to travel to France and Italy and Spain, and we shouldn't allow them to do that. The Council of Europe report strongly suggests that Europe should adopt a Magnitsky Act, and the European Parliament has recently passed a resolution strongly encouraging the European Union to adopt a Magnitsky Act. But this is where the theory versus the implementation gets separated. The European Union is in a sort of bureaucratic stalemate at the moment, as far as I can tell, and it, I think, requires real pressure from member states of the European Union to act. And since the initiative started out at the Dutch in Holland, it seems to me that that's one place where pressure can be applied, that the Dutch Parliament can put pressure on the Dutch government to follow through on their initial forays. But more importantly than that, as far as I understand, everybody views the current EU proposal as solely a Dutch proposal, and it would help tremendously if 1, 2, or 3 other countries joined the Dutch in calling for an EU Magnitsky Act. We currently have initiatives in the parliaments of France and Germany, Sweden, Romania, the Czech Republic, Denmark, Ireland, and so our hope is that 1, 2, or 3 of these countries will, or parliaments of these countries will pressure the governments to sort of join the Dutch initiative. Without these types of external pressures, I think that nothing will happen. But with these pressures, it's very likely that something could happen. So I hope that all those listening to me will encourage members of parliament from those countries and government officials from those countries to act decisively in pushing for Magnitsky Act. Thank you.
Unfortunately, Mr. Gattolin from France had to leave, but we know he strongly supports us. So, Mr. Omzit, if you have any comments, please.
Well, thank you very much for organizing this meeting. It was very important that we keep pushing. That's the difficult thing. And Jarek for giving a concrete proposal, because we have to keep working on that it should be ready. And the EU, it's the Commission that is the only one that can propose legislation. The Council of Ministers cannot, but they shouldn't be able to deny that there are plausible alternatives. And it should be possible with a number of people here to write a common paper. And if the Italian government, I know you're not in the government, or any other countries are ready to do that, I would be willing to start with the group MP and just make a common paper with a number of MPs to make sure that we put a proposal on the table and keep some pressure. It was very timely again to hear Eleonora, Aliaskar, Emin and Anna telling what it means, because often we forget in our, well, we do have our problems, but we don't have these problems in our countries. And it's a timely reminder why pressure is really needed. And thank you very much for sharing what it means for your life when your government, or in some cases the government of a country which is occupying part of your country, is doing to you. If any, so I will pick up what Bill said. It shouldn't be solely a Dutch proposal. If there are 2 or 3 other countries doing this, it would be extremely helpful and would make more of a chance of getting it. And then, yeah, Anna, you said some of the perpetrators are in government in Europe, and that is a real problem. But that's also one of the jobs here at the Council of Europe in our monitoring committee. And make sure you keep providing us with timely information, and which most of you do, with very precise information which allows us to ask very precise questions. Sometimes it looks very tedious, boring, whatever. But I can tell you, governments don't like those questions. They send their ambassadors, they send their PR agencies, they send anything onto me to make sure I don't ask. And usually when they do send their ambassadors or PR agencies, I know I've asked the right question. So please continue that, and we will continue this work. And thank you very much, Roberto, for organizing. Yeah, and Paula.
Thank you. Thank you for your comments. So, Senator Rampi, maybe you would like.
I just believe that it's very, very interesting, the low point, and so what we learn today, and I believe that we are, we give this to the disponibility of everyone who wants to work in his parliament, because that's the real what we have to do to implementary in every European parliamentary, and trying to have Magnitsky at global really. And also I have to thanks really all of you for your very intense what you say here. We really believe that the people. I've been in Kazakhstan. I met your mother. I saw the process of your father. I saw him just not in jail because I wasn't able to do that. I met other 2 prisoners, but not your father. But I saw him. I believe that when we speak about human rights, every time we have to remember that it's not 2 words, but there are a lot of people like you, like people you speak about, like your father, behind the 2 words. So that's the reason because we are here. Thank you.
And before starting the Q&A session, I would like to ask to Eleonora Mangelli from Italian Federation for Human Rights for some comments. Thank you.
Thank you, Paula. I would like to thank the members of the Parliamentary Assembly of the Council of Europe for their support to this important campaign, as well as the activists, the victims of human rights abuses, for their important testimonies. The Italian Federation for Human Rights, as most of you already know, operates in Italy and worldwide, and we promote protection of human rights, and through monitoring and reporting human rights violation, we come in contact with different stories, different victims of abuses from different countries where fundamental rights and freedoms are systematically violated. We have been following several cases. Today we have listened to the case of Moldova, Kazakhstan, Ukraine. I personally took part in a mission recently in Ukraine when I first met Eleonora, and I heard about the case of his father. And so today, I personally I want to also focus on other countries because we are following the human rights situation in other countries as well, such as in Venezuela and in Iran. In particular, regarding Venezuela, we have followed closely the case of Lawrence Saleh, one of the leaders of the democratic opposition in Venezuela, who received the Sakharov Prize at the European Parliament. Saleh spent 4 years inside the brutal torture chambers in Venezuela. He was detained without trial, and let's think that his audience has been postponed 52 times. Saleh now is free, and he was released to Spain in October 2018, but it is now our responsibility to continue, thanks to his strong testimony, which is probably the most detailed and frightening description of what it's like being a political prisoner of that regime. And we really want to give voice to all the people who are still suffering these violations in Venezuela. Regarding Iran, also here we got a long list of testimonies. I can make the example of two among the most popular cases of abuses. The case of Nasrin Sotoudeh, the prominent Iran lawyer, Iran human rights lawyer, arrested and convicted of charges relating to her work. As well as the case of Ahmadreza Jalali that we are still following very closely. Jalali is a respected scientist, well known within the international community, who worked in several European universities and was arrested in Iran 3 years ago. He worked at the time at Italian University, Crimedin, convicted of espionage with no material evidence provided, except for a forced TV confession, following a secret and a hasty trial led by Revolutionary Court, without allowing any defense submission, and then he was sentenced to death. These two stories, as we said, only show a part of a wider systematic violation of human rights in Iran. Lack of free trial, lack of transparency, forced TV confessions, torture and other ill treatments, execution of juvenile offenders, harassment of human rights defenders, and suppression of the rights to freedom and expression and religion. All elements there are reminders of the fact that sustainable improvements regarding the situation of human rights in Iran are not possible without a fundamental change in judicial system, in Iranian judicial system. Those countries have been subject to traditional economic sanctions already. However, the result is questionable, and the human rights defenders know very well that there's a great need to, for a more effective instrument. And this instrument can be the Magnitsky law, which targets human rights violators. And in this context, just want to say, and then I conclude that the Magnitsky sanction would represent a valuable instrument for the protection of human rights worldwide, as addressing to individuals could also solve the problem of a lack of political will towards the imposition of traditional sanctions. Besides, it appears highly appropriate in order to avoid impunity of individuals who are holding key roles in these regimes, especially, and I think, for example, to Iran, especially in the justice administration and penitentiary system. And these persons were directly responsible of some of the most serious abuses. However, for such law to be effective, to have a meaningful impact, it's crucial that more states, more countries, and Italy just started the process thanks to Roberto, and other key international actors like European Union follow the model and support its implementation. And that's all.
Thank you. So since we have to conclude our session, we have 5 minutes maximum for a Q&A. If any one of you would like to raise a question, please, before introduce yourself.
Hello, thank you very much. I'm Dr. Greta Moscavo from Global Ukraine Foundation. I have a question for Mr. Jared Gigenzel. Thank you very much for your broad explanation and presentation. Is it possible, for example, to apply for Magnitsky law, global Magnitsky law, for lack of investigation, for lack of action? For example, in Ukraine, we have our Minister of Internal Affairs and our General Prosecutor, who are directly responsible for no investigation, lack of investigation for example, deaths on Maidan, 700 for around attacks on around 70 activists, anti-corruption, and also for the death of Katerina Gandzuk, who suffered from acid attack 6 months ago. What can we do in such case?
So you're talking about failing to investigate as opposed to actually imprisoning political prisoners, etc.
In predatory state-society relationship, we have such kind of situation with captured institutions and lack of investigation and very strong political responsibility.
Yeah. Well, I mean, I think it sounds like that can be combined with examples of political prosecutions and political outcomes. Ultimately, we're looking for gross human rights abuses. The failure to investigate systematically focusing on, persecution of human rights defenders and others, but the failing to investigate crimes against those kinds of people, if done on a widespread basis, could potentially be evidence that could be part of an application or a request for global Magnitsky sanctions to be imposed against those kinds of people. I think it's, the safest route would be when you're looking to go up against, for example, a general prosecutor, as I was describing in my PowerPoint, and I can share that with you. You want to put together the entire case of what they have done and what they've failed to do together, with as many examples of what you're talking about. And ultimately, it's about demonstrating that they're the worst of the worst, but a general prosecutor in a country is undoubtedly a potentially good target when you're talking about a government that is engaging in human rights abuses of different kinds.
So one more question.
Thank you. I'm Karina Moskalenko, a Russian human rights lawyer, and I was consulting some people close to Magnitsky, including his relatives. And my question to all of the panelists: do you know what happened with the Magnitsky case before the European Court of Human Rights? And can you imagine how valuable would be the judgment on the Magnitsky death, defining that this killing or death was a result of non-compliance of the Russian authorities with their positive obligations on right to life and procedural obligations. You know that in November 2009 that happened. In 2014, the case was communicated to the Russian government. Today we live in 2019. I realize that this court is overloaded with their complaints, and most of those complaints are very actual and important. But what is more important than Magnitsky case, and having even priority on such type of cases, we still have no the judgment. Who care about that? That until today we have no judgment on Magnitsky case. The second question concerned the situation in Iran. We've heard about Iranian colleague, advocate, who was sentenced to 33 years imprisonment and some other physical punishment, which shocked all us Russian human rights lawyers, and we are urged to help this lady. We have prepared our complaint in Russian, English, and Persian, and we would like to know where to file, with which authorities we should file this complaint on behalf of the March. It is a Russian movement of responsible women lawyers movement like this. So please give us impression where we should do and to whom we should complain.
I can have a correct response maybe to your questions regarding, but I want to give you a parallel example case with Elmar Hosseini, because the person, journalist, corruption exposer killed in 2005. And today is already 14 years, and recently, 1.5 years ago, the European Court for Human Rights make shameful decision. You just say for nothing wrong, you just say for you need to pay to widow like 25,000 compensations, and it's many problems. I understand what your main point, especially in case with very huge international attention like Magnitsky case. Even now we saw, for after many years, still no clear decisions. And we have another case in Azerbaijan in 2017, Mehman Kalendarov, blogger, which is dying in the same condition as like Sergei Magnitsky. But you know, his family, after strong pressure by authorities in Azerbaijan, decide not apply to the court and say, for we don't have relatives like him. Person die in the detention center. He tortured, and after they say, for he makes suicide by himself. But no one responsible for these issues, and now we need to ask also European Court for Human Rights. If in countries like Azerbaijan, victims, Bill Browder, they make great job for Magnitsky, the international recognized case, but person like Mehman Kalendarov, which has died 2 years ago in the same condition, and when family not able to apply, family don't want to apply, they say, we are not touched with them. We need to mechanisms. When Council of Europe institutions need to think about this, for if someone tortured and died in the prison, whom should be responsible? That's maybe.
Okay, and last comment, very last one by Jared. Thank you.
Thanks so much, and Ms. Mosklenka, great to meet you here for the first time. I know your reputation exceptionally well, and you're one of the leading human rights lawyers in the world, and I am honored to be in the room with you and look forward to talking afterwards. So two things. One, about Magnitsky and not there being a judgment from the European Court. Unfortunately, as you know well, it's not surprising, and it's of course shameful. There are no easy ways forward on this. I think that the targeted sanctions on gross human rights abusers is very, very important. I actually will be publishing with Memorial Human Rights Center shortly a massive new report on Russia's political prisoners, which I can show you a little bit of here now afterwards. We're making it public at the end of the month, but we've identified 16 perpetrators that are responsible for the imprisonment of political prisoners in Russia, 8 with command responsibility, 8 judges, prosecutors, and investigators involved in the most number of cases of political prisoners. And going after the perpetrators that way is especially important when you can't get justice, or justice takes a decade or longer, in quotes, to the European Court, and then you get a $20,000 euro judgment that is really meaningless. On the issue of Nasrin Sotoudeh, the one thing I would also say, and I don't believe she currently has international counsel, she needs international counsel, and I actually worked with her during her prior imprisonment, but we really do need to take the case to the United Nations Working Group on Arbitrary Detention. It's the only body that will really be in a position to be able to render an opinion. Even in the absence of information, you put forward arguments, of course, about the violation of the lack of presumption of innocence, the violation of lack of public trial, which is required under international law. And so this is one of the places where we need to initiate on her behalf a formal legal procedure against Iran as one of many mechanisms to put international pressure.
Thank you. So we can conclude our side event, and thank you very much for attending this.